Good morning, everybody. Good morning, good morning, good morning. Come on down, sit down if you're at the kettle. We are about to start. Use the chat box to tell me that you're here, guys. And I would love to hear from you. Cecile, morning. It's afternoon for you now. Morning. Just give them a few minutes to kind of get settled, and then we will get the show on the road. Third coffee. How have you not got the shakes yet? Have we got anyone else that's found the chat? If you can't find the chat on the left hand, on the right hand side, if I get my left and right correct, on the right hand side at the top, you have chat, questions, poll, and maybe people. I'm not sure what the settings are. But if you don't have people, it's no big deal. We have the chat function, and you can talk as you wish. If you do have any questions, it's easier to put them through on the questions tab so that I can monitor if a question has been answered or not. So if you've got any particular questions that you're burning through, I've already asked Ibrahim my ones. Host priority. But yeah, it's that if you put any questions that you have, the reason why you were coming here today to be answered, we can get them on. But if you're just here for an update, that's great. So yeah, but actually, it'd be good to know in the chat why you're here, other than seeing that you wanted to see my lovely face and obviously Ibrahim's as well. Would be good to know. I've only got 2 people that have actually written in the chat so far, so I could do with a couple more people telling me they're alive. I'm definitely not a morning person, so okay, cool. Just great to get some information. Fabulous. We've got a small group today, I think. Oh, got a couple more people connecting. If you find the chat box and say hello. To check my thinking on CCPA and to see your lovely face. You see my lovely face all the time. Morning, Sonia. Okay, wanted to find more about CCPA and how it compares to GDPR. Are you going to cover that kind of thing, Ibrahim?
Yes, I am. Yes, Emily.
Fab. All right, let's get this show on the road. No more dilly-dallying. I'm basically going to let Ibrahim introduce himself because I don't think I could do it justice, because he is a fantastic guy working for Act Now Training, or should I say owning Act Now Training. Hopefully you know who I am, Emily Overton. I am the Information Rights Group Chair. I'm looking at doing a webinar every month on the topic of information rights. We don't have a set time. Those of you who remember me from my IRMS London days of doing every Wednesday at 6. I think it's easier for me to do whatever time that the speakers can do, because I'm very aware the people that come on, like, speak on these courses are very busy people, and I aim to do a certain level of difficulty or let my users know what they're expecting. But other than that, let's just get the show on the road. You can ask questions throughout, and either I will interrupt Ibrahim or he will see them and answer them. Yeah, let's go for it, Ibrahim. Over to you.
Thank you very much, Emily, and good morning, everyone. And thank you for the opportunity to present today. I'm always a fan of the IRMS and the wonderful work they've been doing, and Emily's group in particular. So it's great to be with you today to talk something other than GDPR. Well, I say other than GDPR, I will be touching on GDPR as we go along. Primarily, we're here to talk about the California Consumer Privacy Act 2018 and how it compares.
Oh, 1 second, Ibrahim. They're saying that you're really quite quiet, and it's dropped quite considerably since we were testing.
Let me just make sure everything is in place, Emily. Bear with me. My microphone is on.
Are you able to see in your settings to turn your microphone up?
Yeah.
Am I quiet, guys, or is it just Ibrahim? It's
Okay.
just Ibrahim. Okay.
Let me just bring the microphone a bit closer. Is that any good?
Yes. It's sort of a, I'm going to get closer. Like,
Yes.
sort of,
Is that okay? Or shall we?
yes, that's a lot better. Well, it is for me. Is that better, get everyone? I keep on saying, guys, it's a really bad format. Everyone, can you hear him a lot better now? Yes. Okay.
Samantha,
Right.
you okay? Can you hear me?
Yeah. False start there, but Carrot, you want to try
Okay.
again?
Well, I was just saying how wonderful the IRMS was. And today I'm going to be talking about the California Consumer Privacy Act 2018 and comparing it with GDPR. What can we apply that we already know about GDPR? What can we look forward to in terms of development of the California Consumer Privacy Act? A little bit about myself. I'm a solicitor and director of ACNO Training. I've been running the company for almost 20 years. We specialize in data protection and freedom of information law. We training and consultancy. Increasingly, we're looking at other jurisdictions as well. We've done some training in Dubai with their data protection law, which is similar to GDPR, and also now the CCPA in California as well. So the purpose of the presentation really is to look at CCPA, how similar or how different is it to GDPR? What can we apply that we already know? So happy to take your questions as we go along. I'll let you have my email address as well. If anybody wants a copy of the slides, more than happy to share that as well. In fact, let me just get that out of the way, send you my email address there. Okay, first thing to note is California, in fact, the US, start with the US, has no comprehensive privacy legislation. Some would say, well, of course, the UK doesn't either. And that's true, but GDPR is the closest we're going to get to comprehensive privacy legislation. And of course, we have the Human Rights Act, Article 8, the right to privacy. So we're almost there. The US is very much far behind, and I don't think we're going to get there. The Biden administration, if you look at the kind of people that they have appointed to the tech roles, there was talk previously that if he won the election, we would see federal privacy legislation applying across the whole of the US, protecting individuals' privacy, not just in terms of their personal data, but in terms of other aspects as well. That's not going to happen. So what do we have in the US? We have piecemeal legislation which applies to different individuals or different types of personal information, but there's no comprehensive legislation. So we've got the Video Privacy Act, Health Insurance Portability and Accountability Act, so that protects individuals' health information when they're sharing it with health insurers. The Graham-Leach, Bailey Act, children's information is protected by the Children's Online Privacy Protection, or COPPA as it's called. So no comprehensive privacy legislation. As we know, GDPR spreads its tentacles wherever there is personal information being processed. GDPR applies, whether it's on paper, on computer, video, audio, CCTV images, in some cases even manuscript notes. The US doesn't have anything like that. The closest they've got so far is, of course, the CCPA, California Consumer Privacy Act, which on the face of it, we think, well, that only applies to California. Well, we're going to answer that question. Is there extraterritorial effect when it comes to CCPA? But also, it's important for us to understand, as data protection professionals primarily operating within Europe, it's important for us to understand the reach of CCPA, but also California being the biggest state, the most populated state, probably one of the richest states in the US as well. In terms of legislative developments, whatever happens in California tends to spread across the US. And I'll spend a little bit of time towards the end looking at other legislation in other states, which not entirely the same, but sort of they've caught they've caught onto the coattails of the CCPA, and I think we're going to see this spreading across the US. So whether we get a federal piece of legislation similar to GDPR, I don't know, but other states are going to follow suit. And if they follow CCPA, then even those of us in Europe, especially those of you who work for large corporations, companies that are selling their wares across the world, you may inadvertently be caught by the provisions of CCPA. So that's why it's important. So when did the CCPA come into force? 1st of July 2020. I say it came into force. It actually was passed as legislation prior to that, probably about 6 months prior to that, but it wasn't fully enforceable until the 1st of July 2020. Having said that, there is a 6-month look back period. So even in July, companies could still face enforcement action for what they did 6 months prior, which is interesting because in the UK, legislation normally does not have a retrospective effect. So CCPA, we've got the actual legislation itself, but together with the legislation, the Attorney General of California has to produce a set of regulations. So you've got the Act itself, but to fully understand the Act, you have to read the regulations. So GDPR primarily, to fully understand it, or should I say UK GDPR, we've got the UK GDPR, and allied to it, we've got the Data Protection Act 2018. And then from time to time, of course, the Information Commissioner can produce codes of practice. Here, if you read the CCPA itself, the actual statute, it's just the bare bones. The real meat of the provisions you will find within the regulations, which is different because obviously in GDPR you want to know about subject access. You'll find everything within, bar the exemptions of course, you'll find them within Article 15. So CCPA very much relies on these detailed regulations. So far there are 29 pages of them, and these regulations keep changing. So we are now into the 5th version of the regulations. So that's important to bear in mind. So not only we've got the legislation itself, the CCPA, but we've also got the regulations, and really you need to download and read both to get a fuller understanding of the legislation. So as we go through, we're going to talk about CCPA and how it compares to GDPR. And I'm going to assume some knowledge, of course, you being practitioners of the GDPR. I'm going to say GDPR, although, of course, as I say, in the UK, we are UK GDPR. Key themes which come through the legislation, which are familiar to us in the UK. CCPA requires businesses that have to comply with it, businesses that are covered by the CCPA, transparency when processing personal information, and I'll talk about the definition of personal information. So it's about openness, transparency. It's about letting people know, California residents, what their information is going to be used for. We're familiar with that in the form of privacy notices under the GDPR. Secondly, it's to give consumers some control over their personal information. Up to now, they had no control. Businesses could gather it, use it, share it, sell it on, make lots of money out of it, and there was very little that consumers could do about it. So now they have a set of rights that businesses have to comply with. Some of them will be familiar. In fact, most of them will be familiar. And I'll talk about these in detail. To know and access the personal information being collected about them, to know whether their personal information is being sold and to whom, to opt out of having their personal information being sold. That's something interesting, which we don't directly have under the GDPR. To have their personal information deleted upon request, we have that. And interestingly, this is not something specified within GDPR. I suppose it is sort of implied, to avoid discrimination for exercising their CCPA rights. So if a California resident exercises their rights, they shouldn't be discriminated against. They shouldn't be harmed in any way. So two themes which come through both CCPA and GDPR: transparency in terms of what businesses do with individuals' information, and secondly, giving individuals some level of control over how their information is being used, how it's being processed, how it's being shared. What are the consequences if a business does not comply with CCPA? First thing to note is that there is no central regulator. There is no equivalent of the Information Commissioner. And on the face of it, it seems as though there is no high levels of fines, no 20 million euros, no 4% of gross annual turnover. But I'll come on to that. Who takes action? Primarily, it's the job of the Attorney General of California to enforce the CCPA. He can take action in the courts to fine organizations, to award damages to individuals. The Federal Trade Commission overall has responsibility for this kind of consumer legislation as well. It can also take action. Unlike GDPR, there is no direct private law action for any breach of CCPA. As we know, GDPR, an individual who suffers distress or damage as a result of any breach of the principles or the rights, they can take action directly against the business or the data controller. That's not the case within the CCPA. The direct right of action only relates to a security, a data breach. But of course, there's the reputational damage as well. Interestingly, I'll talk about fines and damages and the levels. Interestingly, when before a business can be sued or can be prosecuted under the legislation, an individual or organization needs to serve notice on the business. And the business has 30 days in which to get their house in order. They have a 30-day cure period. 30 days to put things right, which is interesting because we don't have that within the GDPR. So I mentioned that there is no central regulator and there is no high-level fine. Well, that's only partly true. I mean, there is no regulator, but in terms of fines, well, for every intentional data breach, every intentional breach of the CCPA, the courts can award can issue a fine of $7,500. You might think that's not a lot, but if a business collects 100,000 email addresses and decides to sell them on in breach of CCPA, that's 100,000 times $7,500.
Can I ask a question?
Yeah, please do.
How do you define intentional? As in, like, you meant to do it?
Yeah. What the legislation talks about and the regulations is that it's about if the business knew or ought to have known that they were then that could be an intentional breach. Obviously, we're still waiting for some case law around this. There's a couple of cases going through. In fact, there's a number of cases going through court, so we'll know a bit more about that. Because obviously, if it's not an intentional breach, then they could argue for a much lower level of fine or penalty. So I think that's going to be a key area. But generally, it's meant if they knew or ought to have known that they were breaching CCPA. Like the UK, ignorance of the law is no excuse. So it'll be interesting to see how they try and wiggle out of the fact that it was an intentional breach.
I was seeing the word intentional in a different light, on the idea of like, yeah, let's just do it anyway.
That's obviously a clear example of intentional, but often that's difficult to prove unless obviously you have internal records and internal minutes or something. But even knowing or ought to have known, that's enough to make it intentional.
I'm just going to put out there the records management klaxon.
Yeah, absolutely. Thank you. So lower level, if it's $2,500 for each non-intentional breach of the CCPA. Remember, this is not just for a data breach, i.e. what we consider a security breach. It could be any breach of the CCPA, and we'll talk about the provisions. In addition, individuals have a right to sue for damages. Remember, at the moment, that only relates to an actual security breach. So $100 to $750 in damages awarded to individuals or in class action lawsuits. America, of course, is much ahead of us in terms of civil actions and class action lawsuits. There's big firms of lawyers specializing in this. And we're seeing that move towards the UK as well. Obviously, Data Protection Act 2018 allows that as well. British Airways, Marriott, various others are going to be very soon the victims of class action lawsuits. Lots of firms going out there.
I find that the American side of these things is that it's actually a lot more scary CCPA for me, because it's a suing culture almost.
Absolutely. Absolutely, yes.
The British are very sort of quite, it's the last resort, whereas you trip over something in America, I'm going to sue the pavement.
Absolutely. But also here, Emily, now British Airways, Marriott, various others, recently Ticketmaster, there are firms of solicitors that just specialize in, they used to be specializing in tripping and slipping claims. Now they're specializing in data breach, and they're just saying, have you had a data breach? Let us know. We'll tell you if you've been a victim, and then we'll claim on your behalf. And if it's a couple of £1,000 for free, so to speak, I think more people are going to want to get involved.
It's sort of like it feels a little bit like the intentionally crashing into stuff, actually going out there and looking for people that are doing wrong and calling them out on it.
Yeah. Some would say it's claims farming. Others would say no, they're giving people what they're entitled to and making big business aware of the consequences of their actions. So two sides to it, I suppose. Already, we're seeing some class actions, some court actions. Salesforce suffered a data breach, and that involved credit card details of a retailer being available on the dark web. Salesforce is being sued under the CCPA. Same with a company called Clearview, and lots of other cases are going through the courts at the moment. But at the moment, it's quite a slow process, so we've not had any actual decisions as yet. But I think it's only a matter of time. And it's only a matter of time before the lawyers in the States look to big business, certainly initially in the UK and in Europe, that may be caught by CCPA. So hence the next section, which is about the extraterritorial effect. Because if they see the likes of British Airways, obviously they have customers all over the world. Same with Marriott, then there may be scope for them to use CCPA to bring to book, so to speak, these big companies within the EU as well. So coming on to the effect of the CCPA, as in the extraterritorial effect, can we in the UK relax, especially if you work for a business or corporation, that CCPA doesn't apply to us? Because of course it says California Consumer Privacy Act, not World Privacy Act. Well, CCPA has an extraterritorial effect. GDPR or UK GDPR applies to any organization, any data controller that is processing information, even though it might be established within the UK or the EU, if it's offering goods or services to any company which is abroad, but it's also offering goods or services to UK residents or EU residents, it's caught by GDPR. In the same way, we have to be careful when it comes to CCPA. CCPA talks about the personal information of California residents. Okay, so unlike GDPR, it's not everybody's personal data. First of all, it has to be the personal data of a California resident, somebody who lives within California, or to quote the regulations, every individual who is in the state for other than a temporary or transitory period. Somebody living in California, they might not be a California citizen, but also California citizens, i.e. those who are domiciled within the state, but for a temporary or transitory period, they are living within the outside of California. So the definition is quite wide, as long as it relates to somebody living in California or somebody who's a domiciled citizen of California, but they're living outside of the state. It could be anywhere in the world. So automatically, somebody, say for example, a university that is processing the data of a Californian student could be caught by CCPA, as long as it's processing personal information. Now, the definition of personal information is, well, very wide, and I would argue it's similar to GDPR. Any information which relates to, describes, is reasonably capable of being associated with, or could be linked with a particular consumer or household, e.g. name, address, IP address, passport numbers, etc., etc. So I don't think there's much to be done in terms of the definition of personal data, as long as it relates to a California resident. Okay. Some information is excluded because it's primarily covered by other legislation, medical information covered by other legislation, information protected by clinical trials. Interestingly, employee information. We're used to GDPR applying to all data, including employee data. Here, in their wisdom, they've decided to exclude employee information, but just for 1 year, and that's not going to be extended. So July of this year, CCPA will apply to employee information. Again, if you've got employees, Californian residents, but they're working in the UK, or you're processing their data for whatever other reason, you could be caught by CCPA. So we know that the definition is very wide. Information about living identifiable individuals, and it's got to relate to a California resident. But do you have to actually be in California to be subject to CCPA? Well, let's look at the definition of a covered business. This is within the regulations as well as the Act itself. First of all, you could say this is the definition of data controller. That's the term that we're used to within the UK, within Europe. First of all, CCPA applies to for-profit entities. You have to be in the business of making a profit. So unlike GDPR, CCPA does not apply to public sector organizations, nor does it apply to charities. You have to be in the business of making a profit. Primarily, it's geared towards businesses. You have to be doing business in California. Okay. Do you have to be physically doing business in California? This term of doing business in California isn't actually defined. But if you take their tax legislation, because it uses the similar sort of terminology, it talks about doing business in California consists of actively engaging in any transaction for the purpose of financial or pecuniary gain or profit. And an out-of-state entity can be considered as doing business in California if it meets certain thresholds. The perceived wisdom, and having checked this with lawyers in specializing in this, they say that it's conceivable that even an out-of-state business collecting, selling, or disclosing personal information of California residents can fall within the scope of the CCPA. Because traditionally, back in the days before the internet and online selling, you could say a business is doing business in California if it has a physical base within California. Now you don't have to have that. You could be anywhere in the world. You could be in the UK, you could be in Africa, in the Middle East, but still doing business in California. It's not right that you wouldn't be caught by CCPA. California residents would not have the right to control and access and see what their information is being used for just because you don't physically happen to be in the territory itself. So I think that it is important for businesses that are selling to Californians, they are selling to their business is available, their business model is around selling to anybody in the world. You've got a significant portion of your customers who are based in California, then I think CCPA applies to you. So don't just think, oh, it's California, it's Silicon Valley businesses. Yeah. So as I say, Emily, I think that I don't think it's restricted to Silicon Valley. It could be anywhere in the world, anywhere in the States even. You're doing business if you are selling to those customers, if you are processing their information in some way with a view to, remember, a view to a profit. So data brokers and others, Experian and others, Equifax, they deal with American companies, they deal with American individuals' personal information as much as they do in the UK. So I think that's something to bear in mind. Think about how much do you actually do business in California? How much information do you hold about Californian residents? If you do, the safer bet is to say that CCPA applies. It is, but then Claire, if you read the regulations, if you read around CCPA, what you find is that, I mean, it's not an example of clear drafting. If you think GDPR can be a bit convoluted at times, what we find, and it's not just myself, but lots of experts in this area, they say that there's areas where there's inconsistencies between the actual legislation and the regulations. Okay, so we're doing business in California. Are we collecting personal information about California consumers? Yes. We're determining the means of processing, i.e. we are the data data controller, so to speak. Then on the face of it, CCPA applies. So all the boxes in blue have to be ticked, and then in addition, you have to be doing one of the comply with one of the 3 criteria on the right hand side. So you have to have an annual gross revenue of more than $25 million, or you have to buy, receive, sell, or share the personal information of 50,000 or more consumers, or you have to derive 50% or more of your annual revenue from selling personal information. So if you can say yes to all the boxes in dark blue and yes to one of the criteria in grey, then you are subject to CCPA. As far as UK businesses go, remember, if you're from a public sector organisation, you're not a for-profit entity, CCPA will not apply to you. If you are a charity, again, it will not apply. But if you are a business, and especially if you're engaged in selling worldwide, then you have to think very carefully as to what extent you are processing the data of California residents. If you are, it's better to err on the side of caution and consider what you need to do to comply with CCPA. So we've been through the criteria, just moving on. It talks about collecting personal information. What does that mean? Buying, renting. So even though you yourself are not collecting the information, but say, for example, you are a universities. Are they a for-profit entity? That's another question. But say you're a university and you are buying lists of residents in California or students in California that you could potentially market to. On the face of it, even though you're not collecting the information, you're buying it, that could be
Is that
covered by
their version of processing?
Excuse me. The term processing, Emily, isn't used. They use terms like, as I say, collecting, selling as well. We're going to come on to. It talks about selling here.
Yeah, it's their version. That's what I asked. Yeah.
But yeah, so yeah, their version of processing, you could say. Selling, renting, releasing, disclosing, disseminating, as you can see, very much in keeping with the definition of processing under GDPR. So whether you're collecting, whether you are selling obviously means that it has to be for monetary or other valuable consideration, then potentially CCPA will apply to you. So I think that
I think that's quite a smart thing to do, to use those kinds of words, because I don't think in the UK that the word processing is really understood when it comes to personal data. So people don't see receiving an email as processing personal data, but if you're receiving it, collecting it, and all those kinds of words, I think would be understood a lot better.
Yeah, certainly that, and that's a fair point. And people, even just holding information is processing, but people don't think of it as processing. So you're absolutely right. Once we understand who CCPA applies to, then it's quite straightforward, the rights, because they're very similar to the rights that we have within the UK under the UK GDPR, and in Europe with their GDPR as well. First of all, to know and access the personal information being collected about them. That says to us privacy notice. Every business has to have a privacy notice later on, and again, this is the sort of one of the inconsistencies. Later on in the regulations, it talks about a privacy policy. It has to be updated every 12 months. A business cannot collect additional personal information or use personal information collected for other additional purposes without providing a further privacy notice. So just like within the UK, Article 13 and 14, it's quite prescriptive as to what should be included within the privacy notice. So categories of personal information it has collected, sold, or disclosed in the last 12 months. Notice our privacy notice doesn't have a sort of a time limit. Here it talks about only in the last 12 months. Categories of sources of information, the purpose for the collecting and the selling of the personal information, categories of recipients, a full explanation of the consumer's rights, and where a business is not involved in the business of selling personal information, a statement to say it has not sold consumers' personal information for the last 12 months. Like the GDPR, the privacy notice has to be in plain language. It has to be noticeable and readable. There should be a very clear sign pointing people to the business's privacy notice on the website. It should be in the business's business language, should be accessible and readily available, which I think is same as noticeable, really. So that is the first right, not very dissimilar to our Article 13 and 14. Second right, which individuals have, is the right of access. Okay, the right of access.
I like the cartoon. It's brilliant.
So they know that their information is being sold. Just to go a bit further, to have their to access. One is to know what information is being collected. The other is to access that personal information. Article 15, subject access. That's what we know. They have a right to receive a copy of the information, as well as the categories of the information that's been collected and sold, the purpose of the collecting and selling, categories of sources, categories of third-party recipients. Again, very similar to Article 15. Something here is slightly different. First of all, it's free of charge, very similar to the GDPR, unless the request is a repeated request, unless it involves volumes of information, etc., then in which case a charge can be made. There should be a clear process on the website. It should be made very clear how individuals can access their information. Now, interestingly, the right under CCPA, the right of access, only the personal information collected in the last 12 months is accessible by the data subject. So unlike GDPR, where if you're keeping information not doing your records management very well and keeping information forever, and you have hordes of information, well, you have to disclose all of it subject to the exemptions. Here, subject access only applies to information collected in the last 12 months. And interestingly, each individual can only make 2 requests a year to that organization. So they've limited the right of access quite substantially from GDPR.
Do we define 2 requests as an email or like a letter, or like, can you put as many questions in as you like?
That's not defined, Emily, and that's a good question, and I think that will be the subject of perhaps litigation as well, because you're right that it could be that a person can just make a number of requests within the one email. So is it the request itself, or is it the mode of the request? Don't know at the moment.
Oh, there is lots that I could do with that. But also records management klaxon on getting rid of data appropriately.
Yeah. Toll-free number. There's got to be a toll-free number, i.e. 0800 number or whatever that is in the US, that people can ring to make a subject access request. So they can make verbal requests as well, which is interesting. And they have 45 days to respond to a request, as opposed to our what is it now, 1 month within GDPR. 45 days, although it can be extended to 90 days for, just like in our case, for where there's lots of information, where a request is vexatious, it can be extended to 90 days. So that's the right of access. The key difference here is that the amount of information a person can request only for the last 12 months, and it's limited to 2 requests a year from the same individual to each business. Feel free, if you have any questions, to type them into the chat function. Let's look at the right to opt out of sale. This is interesting. Again, no direct right within GDPR. GDPR does give an individual the right to object based on their own circumstances, but that depends. I mean, if they have previously consented to their, it only applies in certain situations. If they've consented to the, if the information is being processed on the basis of consent or contract, then you don't have that right to object. Whereas here, any individual, a consumer, shall have the right at any time to direct a business that sells personal information about the consumer to third parties not to sell the consumer's personal information. So even if they have previously known about it, but they can still object to the sale. Remember, sale, the definition is very wide: sharing, renting, etc., etc. They have a right to say no. And that right has got to be clearly indicated within the privacy notice, but also on the website as well. There's got to be a button that individuals drawing attention to that right, a button that they can press to exercise that right. And indeed, the regulations even set out how the button should look and the color. And
what is the default? So I'm that really annoying host that asks lots of questions.
yeah.
What's the default here?
The default is actually all it says is that the button should be there for people to exercise. So it's not I don't think it's an opt-out, which is what's required within the UK. It would have to, it's an opt-out, sorry, but they would have to slide the button or press the button to exercise that right, as opposed to opting in, so to speak. Yeah.
Right. Opting into opting out.
Opting into opting out. Yeah, that's a good way of putting it. So, i.e., the button that has got to be there, and they have to use the button to exercise their right to say, do not sell my personal information.
But if they don't opt in to opt out, they're opted in.
Then they're opted in. Yes, that's a good way of putting it. As long as the business has explained within the privacy notice. Yes.
Okay.
Opting in to opt
Clear
out,
as mud.
or exercising their right to opt out. Yeah.
Move on.
But the default position when it comes to children, there is a prohibition on selling the personal information of children, i.e. those under 16, unless their consent has been obtained if they are 13 or over, or the consent has been obtained of their parent or guardian if they're under 13. So when it comes to children, it's more that, well, they would have to opt in, wouldn't they? Because the consent of the child is required if they're over 13, or consent of parent or guardian if they are under 13. There is another right. There is another right. Let me just remind myself what that right is. Anyone? Thank you, Claire. Quick as a flash. That's the way I try to draw out.
That was terrible, Ibrahim.
Yeah, I know. But that's the way I draw out the erasure fans, Emily. Yeah. Because they don't normally admit it. Thank you, Claire. Yes, there is a right to erasure, or the right to deletion. You actually play the erasure now. I think that's yeah, cheesy, but also maybe a breach of your delegates' human rights, Claire.
Like the ear burn.
Absolutely, yes. A business that receives a verifiable consumer request, they have the right to request identity in relation to all the rights. So once they can verify that it's a request from a California consumer, from a consumer to delete the consumer's personal information, then the business has an obligation to delete that information from its records and direct any service providers. So you'll be familiar with this if you know about Article 19 under the UK GDPR. When you get a rectification, deletion request, you have to tell others with whom you have shared the information. So in the same way, you, as a business, CCPA business, direct any service providers to delete the consumer's personal information from their records. So the right to deletion, as long as the individual has provided their information, their ID information, then not only should the business itself delete the information, but it's also got to delete the information, ask its service providers, i.e. its contractors, or what we would deem data processors within the UK, they have to be directed to delete their records as well. And I think once again, you've got 45 days. Finally, then, we've got the right to non-discrimination. Okay, an individual should not be discriminated against a consumer because the consumer exercise any of their consumers' rights. So just because somebody's made a subject access request or a request for deletion, they should not be denied goods or services, or that they are charged a different price, or the terms upon which they get discounts and benefits are different.
So if you opt in to opt out of being opted in, you're still allowed to view the website?
Absolutely, yes. That would, I would say, that's discrimination if you're barred from the website because you've not opted in to opt out to opt in. Yes. Yeah. Provide a different level of quality or of goods or services to the consumer, suggesting that the consumer will receive a different price or a rate of goods or a different quality of service. So you can't force people not to exercise their rights by sort of discriminating them against them in any way. So that is, again, different to GDPR. So those are the 5 rights which individuals have under the CCPA. Remember, CCPA applies not just to businesses within California. Any business that is processing the information of California residents, as long as it is a business, as long as it is for profit, has to consider the application of CCPA. Just before we finish, word on third parties. We're used to GDPR requiring you to police your data processors. Well,
you have a couple of questions before you want to move on to this.
Yes,
that's all right.
Yes,
I hadn't spotted them. We have one that says, are there any exemptions to deletion?
Yes, there are. Where it's a, let me just bring up my copy of the legislation. Okay, the exemptions. A business or service provider shall not be required to comply with the consumer's request to delete information if it is necessary for the business or service provider to maintain that information, i.e. it's necessary for them to keep it, to complete the transaction for which the personal information was collected. So they're still a customer, they're still ordering goods or services. We need to keep their information in order to complete transactions, or to detect security incidents, protect against malicious, deceptive, fraudulent, illegal activity, to debug, to identify, repair errors. There's a free speech exemption as well. And there's also scientific, historical, and statistical research as well. There's internal use, to enable solely internal uses that are reasonably aligned with the expectation of the consumer. So, for example, or to comply with legislation, you need to keep the consumer's information for the purposes of your tax records or your internal sort of business management, your records management. That would be okay as well. So there's actually 9 exemptions from the rule about deleting information. So key ones are where it's essential to keep the information to complete a transaction, to maintain good security, including identifying bugs, etc., for research purposes, for internal purposes, to comply with a legal obligation.
We have another question. Are there any exemptions to rely on to withhold data from release under an access request?
Yes, there is. Okay.
Looks like the group love their exemptions.
Yes. Where there's if a business needs to keep the information, sorry, this is about subject access, isn't it? So it's very similar to GDPR in terms of if a business cannot disclose the information because it needs to pass on some of the information to the police, or it's part of a criminal investigation, legal proceedings, to take legal advice. For regulatory functions, it needs to pass on information to the regulator. It may self-incriminate itself in terms of criminal law. If it disclosed the information, then there are exemptions to the rule about subject access. So very similar to the exemptions under Schedule 2 to 4 of the Data Protection Act 2018.
Okay, that's the end of the questions so far.
Okay, thank you. So you have to police your third-party service providers, what we deem as data processors. So once again, there are similar rules in relation to having contracts with them, making sure that you choose appropriate service providers that know about CCPA, that can comply with the legislation themselves. And as I say, you'd need a contract with them as well. Records, it talks about keeping records. That's specifically mentioned within the legislation. So a brief bit about that. Businesses must keep records of consumer requests for at least 24 months. And they've got to keep detailed metrics where they deal with 4 million consumers' personal information per annum. Then there's a detailed list of information that they need to keep about those requests as well. When the request came in, what was done with it, how perhaps even the cost of the request itself. All that information has got to be kept. So there's a detailed list of the kind of records that need to be held by an organization. So at the very least, keeping records of consumer requests for 24 months. General exceptions.
Put it in your retention schedules, because otherwise you'll forget.
Yeah, absolutely. Okay, there are some general exceptions in terms of all the rights. None of the rights have to be complied with. If complying with them would breach any other law, would harm any investigation, etc., where you need to cooperate with law enforcement agencies to exercise or defend legal rights. Interestingly, if you're collecting or selling anonymous or aggregate consumer information which has been completely anonymized, so individuals cannot be identified by that information, then generally CCPA doesn't apply. Interesting one which businesses may rely on, those who are outside, a counter argument to my argument about anybody anywhere could be subject to CCPA. Collect or sell consumers' personal information in every aspect of that commercial conduct takes place wholly outside of California. As I say, we're waiting for more guidance on that as to what extent that's going to curtail the extraterritorial effect. Practical steps, if I was advising when I've done training for US organizations, the usual, and we're used to this as GDPR practitioners, doing a data audit, making sure your policies, your procedures, your records management, etc., is in place, doing a website audit, because the regulations talk about doing things on your website, privacy notice, do not sell button, etc., and of course training and awareness. If you think that was enough, well, wait on. The CPRA, California, forgotten now. Anyway, the CPRA, California Privacy Regulation Act, forgotten the full explanation of the acronym, but this was passed 4th of November 2020. This was on the ballot at the same time as on the election and the US elections. It comes into force on the 1st of January 2023, and it will amend CCPA. Fair to say, it will make CCPA more like GDPR. So it adds additional rights: the right to rectification, the right to limit use, and disclosure of sensitive personal information. So our special categories of information, details of ethnic origin, religion, sexual life, health information, etc. There will be more limits to what businesses can do with that information. It also creates a private right of action for any breach of the of the CCPA, as opposed to just the right in terms of security breaches.
Does CPRA only apply still to for profit?
Yes, so far it seems that yes, it will still only apply to for-profit businesses.
Okay.
Yep. Remember, the CPRA will amend the CCPA, so it will have a second version of the CCPA. Okay, so but the main one is in the middle: creation of the California Privacy Protection Agency for Enforcement and Guidance. So you never know, guys. Learn about this legislation and apply your expertise in GDPR, and you could be poached, or there may be job offers. I know it'll be a wrench to leave the UK weather, but there could be jobs in the California Privacy Protection Agency, their equivalent of the ICO, I suppose. They will be in charge of enforcement and also guidance as well, similar to the ICO. So keep an eye out for that. Because remember, at the moment, there is no central enforcing agency like the ICO. We've got the Federal Trade Commission and we've got the California Attorney General, but the Attorney General has said that he only has the capacity and the resources to take action twice a year in terms of enforcement, because he's got so many other things on his plate. So the Privacy Protection Agency will be welcome, certainly by privacy campaigners. Okay, let's see. So I think we've covered the sort of similarities and differences with the GDPR, but that table just gives you sort of a quick summary. And as I say, you can send me an email and I'll send you the slides as well. But
I
GDPR,
love a good email. Email table.
Yes, it applies to all personal data. Remember, GDPR, CCPA, California residents' personal data.
Ibrahim, we will get these slides uploaded on the IRMS website, so they will be in the IRMS Rights group section, so you can log in and get them, rather than everybody emailing you, please.
No problem. As I say, if I forget the odd email, I don't mind either. Applies to personal. You can see that they both have sort of territorial effect, but I suppose GDPR is much wider. There's no legal basis required to process data under the CCPA. Remember, under GDPR, we always ask, is there a legal basis to process this information? There's no requirement under CCPA. There's no right to opt out of sale in GDPR, but there is specific under CCPA, I suppose. With GDPR, we've got the right to object to direct marketing, and we've got the right to object. No restrictions on rights. Whereas we do have restrictions, the frequency, the age of the data, especially in terms of subject access under CCPA. There's no non-discrimination right under GDPR. Fines, there's a maximum issued by the ICO. There is no maximum under CCPA. There is a maximum per violation, but it depends. If there's 1 million violations, it could be $7,500 times 1 million. So in that sense, there is no maximum under CCPA. And subjects can claim damages for any breach, whereas at the moment, CCPA, a subject can only claim damages for breaches of security.
Okay.
Lots of other, just coming to the end now, so lots of other legislation going through through their legislatures at the moment. Lots of other states are bringing in legislation similar to CCPA. Not all of them as comprehensive as the CCPA, but I think it's just a sort of dipping a toe in the water as far as some of these states are concerned. Once they pass this legislation, any form of privacy legislation, I think it's only a matter of time before they gradually improve it, amend it to make it more like CCPA and indeed more like GDPR. So keep a lookout. I mean,
do you think we'll see this this growing and more colours coming in? When do you think we will go all red?
Most definitely. Give it time, Emily, before we all retire. I think it will. Majority of it will be red. Privacy is the data, as they say, is the new oil. There is concern as about just recently Facebook and their data breach, but the power of Facebook, the power of these big companies in terms of our information to gather, use, share, to profile us, to influence our voting, influence our behavior. I think more and more the Americans are waking up to the fact that privacy is something that is to be respected, and something that big tech needs to be reined in, but also all businesses, as we're all sort of more or less data led. So I think it's going to happen definitely. But the good news, I think, for privacy professionals, especially those people like yourselves and others who are well grounded in GDPR and the old Data Protection Act, is that the skills, the knowledge that we have can easily be applied to US legislation. And so it makes us more sort of, I suppose, more valuable, more in demand. And whereas before data protection jobs were UK based, I think increasingly you will find privacy jobs available across the world, California and everywhere else. So I think that's good.
Yeah. We are slightly running over.
No problem. Let me just finish off then. So as I say, I think I'll skip through these slides. If you want to know more, have a look at our blog. I've done a full blog post on the CCPA, and you've got the details there as well, or you can go onto the website and have a look at our website. Lots of other courses and resources, of course, and happy to answer any further questions offline or online.
What would be good to know is if you would log into the IRMS website, Ibrahim, and pose perhaps some homework or more research stuff, and like links to your blog and stuff like that. I like to put in a bit of where else can we take this in the forum to hopefully generate some discussion for the members of IRMS. So yeah. People are having to disappear. We've got one last thing that we can maybe squeeze in. Presumably, presidential orders and the Patriotic Act still override any of this privacy legislation.
Yes, most definitely. America is big in on its surveillance and government being able to access data. Hence the reason why the Privacy Shield was struck down by the European Court. So yes, all this can be overridden by such surveillance legislation.
Okay. Well, thank you very much for your time today, Ibrahim. I really do appreciate it. Don't be a stranger to IRMS. Like I say, if you log in and post some stuff on the forum, and our members can have a login and continue the conversation on the forums. But other than that, I shall see hopefully my lovely viewers next month. I'd love to tell you which one is next month, but I actually can't remember. So we'll leave it there. And thank you very much, Ibrahim. And everyone on the chat is saying thank you very much, and it was very useful. And goodbye, everyone. When I press end event, everyone will literally disappear. So thank you very much, Ibrahim, and bye for now.
No worries.
Bye.